Today we're going to vote on 12 judicial nominees and one bill, S-2992, the American Innovation and Choice Online Act, introduced by Competition Subcommittee Chair Amy Klobuchar and Ranking Member Chuck Grassley, co-sponsored by myself, Senator Graham, Blumenthal, Kennedy, Booker, Hirono, and Hawley. This bipartisan bill addresses the tactics that dominant tech platforms have used to limit choice by consumers and exclude competitors. I'll certainly have more on this bill, turn to it on the agenda. We also have a new bill on the agenda, S-2710, Open App Markets Act, introduced by Senator Blumenthal and Blackburn, co-sponsored Klobuchar, Graham, Booker, Kennedy, Hirono, Hawley, and myself. S-2710 is being listed on the agenda for the first time and is going to be held over. Many members on this committee on both sides of the aisle have been working on these bills for a long, long time. They've been carefully crafted to address anti-competitive practices by dominant tech companies. I look forward to debating and voting on them. It's I think, a relatively new undertaking by this committee and one that is overdue. I commend the senators on both sides of these issues. I think the importance and relevance of the Judiciary Committee is being tested by this debate today, and I'm sure we will rise to the challenge. I understand several members have asked to delay today's markup of S-2992. I think we have to move forward. We have limited opportunities to consider important legislation and a lot to do. I'm going to try to be as sensitive as I can be to fairness on both sides, naturally. After the Senate bill was introduced originally, the Competition Subcommittee held another hearing on December 15th. 3 witnesses testified, 8 senators attended. In short, there has been opportunity for members to review this bill and debate it. Consistent with the rules of the committee, S-2992 was added to the agenda on January 10th, 10 days ago, so members have had notice that it was coming. The manager's amendment circulated on Tuesday, and obviously members have had an opportunity to review it because 107 amendments have been filed, including 82 from one senator. We're going to move forward with consideration of S-2992 today. Now we're going to turn to today's agenda, and I want to note the run of show. I will speak about 2 of the nominees to be considered, Judge Allison Nathan, Second Circuit, Dale Ho, Southern District of New York, being turned over before turning it over to Ranking Member Grassley. We'll then proceed to vote on the nominees in order that they're listed, beginning with Judge Nathan, concluding with Ms. Trong. As we've done at previous markups, I ask members to await to comment on any particular nominee until they're called, and then at the end of the nominees process, we will consider S-2992. First on the agenda this morning will be Allison Nathan, Second Circuit Court of Appeals, highly qualified, Cornell Law School, clerked for Judge Betty Fletcher of the Ninth Circuit, and then on the Supreme Court for Justice John Paul Stevens. 10 years she served with distinction in the U.S. District Court for the Southern District of New York, authored over 1,500 opinions, presided over 45 trials that have gone to verdict or judgment, set by designation on the Second Circuit on several occasions. During her hearing, she was repeatedly asked what the party not in power in the White House always asks for personal opinions on issues. Some of my colleagues have been as disappointed as we were as Democrats under the Trump administration that Judge Nathan and others have withheld personal opinions on many issues. That's happened in the past. So the anxiety being felt by some Republican members was shared by Democrats when the shoe was on the other foot. There should not be one standard for Republican nominees and another standard for Democratic nominees. Judge Nathan found unanimously well qualified by the ABA. Dale Ho, Southern District of New York. He's a highly skilled litigator with a significant appellate practice. Princeton and Yale Law School, clerked in the Southern District of New York for Judge Barbara Jones, New York Court of Appeals, has spent the majority of his career as a civil rights lawyer, experience in long-running, complex civil matters, and in proceedings for preliminary relief. I'm not going to read this because I want to get into the business of the day. I will tell you that Mr. Ho was called to answer why he posted certain things on social media. And he said, and I quote, "I very much regret the tone that I've taken on social media from time to time. In my role as advocate, I've pushed the envelope to break through, but I regret the times that I've crossed the line with overheated rhetoric. There are some members on this committee who believe in redemption and some who don't. I'm one who does. I hope that my general positive attitude toward redemption is going to be proven right by Mr. Ho and many of the others that I've supported in the past."